Just confirm if that's the live stream.
I did tell him to Doug, and I won't relate the conversations right now, but I'll come and see it tomorrow.
All right, good morning. We're on the record in the 53rd Circuit Court for the County of Sheboygan. And we're beginning our criminal docket this morning. We're providing public access both online and in the courtroom here today. And we have first up, people of the state of Michigan versus Sean Miller. It's file number 20-5993FH. And Mr. Hungerford, you're here this morning with Mr. Miller. We're here for a docket call and also a contempt hearing. Do you know how we're proceeding on the contempt hearing?
Yes, Your Honor. I've had a chance to talk to my client, and there's going to be a plea to using marijuana, I believe, on June 1st, and also cocaine on the May 28th. And there's also going to be a plea that there were certain missed tests in this particular matter.
Okay. All right, Mr. Miller, you want to raise your right hand as best you can, sir? You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Okay, you can put your hand down. Would you state your name, please?
Sean Michael Miller?
Okay, Mr. Miller, you understand that you've got the right to have a contempt hearing at which it would need to be proven beyond a reasonable doubt that you are in contempt of court for violating conditions of your bond. If you are found to be in contempt, it could sentence you to up to 93 days in jail and or a $7,500 fine. Do you understand that?
Yes, sir.
And has anybody promised you anything in exchange for your plea?
No, sir.
Has anybody threatened you in any way?
No, sir.
How do you plead then to the allegation that you're in contempt of
I
court?
plead guilty.
So were you on bond to this court?
Yes, sir.
And as part of that bond, were you to submit to and pass random drug and alcohol tests?
Yes, sir, I was.
And you had to call the drug line every day?
Yes, sir.
And were you ordered not to use or possess illegal controlled substances or any mind-altering substances?
Yes, sir, I was.
Did you miss some of those scheduled tests?
Yes, I did.
And did you, in fact, while you were on bond, use the controlled substance cocaine and the mind-altering substance marijuana?
Yes, I did.
Okay, and did you know that violated the conditions of your bond?
I did, Your Honor.
Okay, well, Mr. Hungerford, are you satisfied with the factual basis?
Yes, Your Honor.
Ms. Goodrich?
Yes, Your Honor.
Well, I'll accept your plea, Mr. Miller. I find it's knowingly, understandingly, and voluntarily made, and there's sufficient basis to believe that you're in contempt. I'll dismiss the allegations about the other tests, as I understand, talked with your attorney and the prosecutor off the record where they've got some challenges to the validity of those and whether they popped that way because of the prescriptions that you have. So we'll dismiss those and not consider those, all right?
Thank you, Your Honor.
All right, so Ms. Goodrich, with regard to sanction?
Your Honor, given the Mr. Miller's past and significant criminal history, we'd ask that his non-compliance with probation for bond for the short time that he was out, that he receive 93 days. Thank you.
Okay, Mr. Hungerford, any thoughts as to the sanction for the contempt?
I would just ask for lesser time, Your Honor. And if in fact, it's a shorter period of time, I would just ask that the bond be reinstated.
Okay.
Thank you.
Mr. Miller, it's not required that you would make a statement, and certainly I wouldn't want you to say anything that prejudices you in your underlying case, but is there anything that you want to tell me before I decide on your contempt?
Yes, sir. Are you on?
Yeah.
I just want to say is, I know using the few times I used, it was a screw up, but it was, I'm an addict, it was hard. I'm not trying to make no excuses, but it was, at the time the people, it's my own fault. So, but it was, as you know, some of the history of that using, it wasn't like I stepped out there and had in my mind, like I said, I'm going to use drugs or anything, but certain circumstances, I was wrong people. I take full responsibility for it, Your Honor.
All right, well, what I'm going to do is on the contempt charge, I am finding you in contempt, and I'm gonna order that you serve 30 days in jail and give you credit for 30 days previously served. Now, your bond continues to be revoked. I have revoked that because of those violations.
Yes, sir.
So what that does is it takes care of the contempt, but you don't have a bond at this point. And, you know, I'm not inclined to reinstate that today, but that allows your attorney to file a motion to reinstate it at any time now. We don't have to wait another 2 months if it's just 93 days. Okay, so you can move. Bond can always be addressed at any of the hearings, and I would be open-minded to considering it. Although, you know, how this worked out, you know, is certainly something I'd consider.
Yes, sir.
Okay.
Can I ask a question?
Yes, sir.
Now, is that, how was I even worded, like, so am I still available to the MDOC now, or like, how's my, I guess that's a question for my
You are
attorney.
not available to MDOC because your bond is, you're in pretrial detention on pending charges.
Okay.
Yeah, so they won't send you back or something. You're not available.
Is my time, should I ask my attorney questions or?
Yeah, why
Yeah,
don't we,
yeah,
we
if
can
you've got
address
questions
these.
about credit or something like that, you should ask your attorney
Okay, sorry.
at a scheduled visit.
Sure.
Now, as to the underlying charge, we have resumed jury operations as well as you well know. I mean, you were the first trial attorney in the year, Mr. Hunkford, so well done.
Will I get an
And,
award or not?
there you go. But we are giving trial dates out, and so if Mr. Miller is convinced that there's no resolution and should be scheduled for trial, I'd give you dates today. If you do think further discussions would bear fruit, perhaps, then I can continue the docket call. It's your choice.
Your Honor, I'd prefer that you continue the docket call. The prosecutor and I are still discussing a possible plea in this particular case, but at present, we're not willing to plead to the charge.
Okay. Well, what we could do is, Ms. Goodrich, any objection to a continuance then?
No objection.
I'm going to continue the docket call then to September 7th at 1:30. The October dates are all booked up. All right, I'll schedule that to be held in person. Thank you. We'll see you then, Mr. Moore.
Okay, thank you. You have a good day.
Okay, thank you, Judge.
Have a good day.
Sure. All right, and the 9:30 case, Hoffmeyer, that's being adjourned, I believe, so we'll be in recess until 10 a.m. then, right?
You're not gonna get them then?
No, we're not going to need Mr. Hoffmeyer. Come on.